Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.
Welcome to Planning for Win, Financial Guidance in Life. I'm Kevin Pinkley. Thank you for joining us today. Today we'll be discussing everything you wanted to know about bankruptcy but were afraid to ask. Attorney Liza Greene is joining us today. Thank you, Liza, for joining us.
Thank you, Kevin, for having me this morning.
You bet. Liza, could you tell the listeners a little bit about your practice and how they could get in touch with you?
Absolutely. I practice with the firm of Laura Dale and Associates in the Galleria area in Houston. We are a small boutique firm practicing primarily in the areas of family law and bankruptcy. My phone number there is 713-600-1717. We're there Monday through Friday, so give us a call. We'd be happy to help anyone out that's interested in our services.
Thank you, Liza. Well, on the topic of bankruptcy, where would you like to start with today?
I think a good place to start is some of the common myths about bankruptcy. People have misconceptions about whether they can even file for bankruptcy, what happens once a bankruptcy is actually filed, what they can expect. A lot of people think filing bankruptcy means they're going to lose all their assets. A lot of people feel like, a bankruptcy means that they're a deadbeat. And I find that most of my clients are in the situation because of some unfortunate life event. Either they've lost their job, they've had an unexpected illness, death of a spouse, and also a lot of times a divorce situation will prompt a bankruptcy having to be filed.
Or all the above.
Absolutely,
Yeah.
yes.
Yeah.
Most definitely.
Well, on those choices, let me back up. So obviously there's just different types of bankruptcy.
Correct.
Okay.
Yes.
So in those parameters, what do we need to know to get started? And if we're eligible for bankruptcy, I would use that term if that's even correct. Yeah.
Okay. Well, there are essentially three different types of bankruptcy filings that an individual may be considering. Chapter 7, which is what's called a liquidation bankruptcy. That's what most people consider a bankruptcy when they're thinking about that. There's a Chapter 13, which is a reorganization. And then there's also Chapter 11, which is primarily for businesses, but individuals who don't meet the debt limits for Chapter 13 may end up having to file a Chapter 11.
Well, if we want, let's start with Chapter 7, since that seems to be the term that we hear the most or considered the most, perhaps.
Right.
Okay.
So Chapter 7 is primarily for individuals who have a lot of credit card debt, medical debt. It's an attempt to discharge or get rid of your unsecured debt. What a Chapter 7 will not do is it will not get rid of taxes. And just to back up real quickly, there's a misconception that you can't ever get rid of taxes, and that's not necessarily the case. I have had many bankruptcy cases where I've been able to discharge income taxes. But again, a Chapter 7 is primarily when we're dealing with unsecured debt, not if you're falling behind on your house or your car or those would be a situation where you'd be looking at a Chapter 13 or a reorganization.
Okay. Well, you mentioned credit cards and medical bills, so I had a few questions with that. So when we discuss Chapter 7, is there like a dollar range that we're talking about, or do we have to be behind by a certain number of payments or time frame? Or
No, not really. In order to qualify for a Chapter 7, you do have to pass what's called a means test, and that is where the court looks back at your last 6 months of income. And then there are certain deductions that you're allowed to take off of your income to determine whether or not you qualify for a Chapter 7. So that would be the first place we start to determine whether you qualify for a Chapter 7. I also look at what your assets are. In any bankruptcy case, you're entitled to certain exemptions. You can keep your house, your
Mhm.
car, your furnishings, those kinds of things. But if you have, a lot of what I call non-exempt assets, such as cash or stocks, bonds, expensive jewelry, those kinds of things, then we might want to consider having to put you in a Chapter 13 rather than a Chapter 7. The goal is to get rid of the debt but not lose any of your assets in the
Okay.
process.
Okay. Is there a cap on a certain dollar amount? Meaning, can file bankruptcy? Well, if we have $10,000 that we're looking at, or if it's $10 million.
There is no cap or any real dollar range.
Hmm.
Obviously, everything's relative.
Hmm.
If you're someone who's lost their jobs, been out of work for a while, don't have any source of income, your unemployment is running out, and you owe $20,000 in credit card debt, that may be overwhelming for you. And so you may want to consider a bankruptcy. On the other hand, if you are working but you're just struggling to make your payments because your credit card debt is $70,000 or
Hmm.
more, then you would consider bankruptcy in that situation. I've had clients discharge as little as $25,000
Hmm.
up to several $1 million. Most of those larger cases are people that have had businesses that have failed. They've personally guaranteed the business debt, and
Hmm.
so now they're unable to pay that back.
Well, if we can do it in the time frame allowed, could you walk us through the process of once someone is questioning, can they file for bankruptcy? What are kind of the next steps that they would go through?
So, of course, the first thing would be to consult with an attorney,
Hmm.
get all your financial information together when you meet with the attorney so they can make a determination of whether you qualify. Once you determine that you do qualify for a Chapter 7, then, at least in our situation, we have the client fill out a complete worksheet. There's a lengthy petition that has to be filed with the bankruptcy court that covers your current financial situation as well as your financial situation for the past several years. Um, Once the client has filled out that worksheet, gathered some documents that we need, the court requires that we get tax returns, bank statements, pay
Hmm.
stubs, those kinds of things together. We then prepare the petition. The client would come in and sign it. We file that with the court. And then after the case is filed in a Chapter 7, they would have to attend a meeting of creditors. That term scares a lot of people because they think they're going to have to face their creditors. In most situations, creditors do not appear at that hearing. And it's an informal setting in like a conference room with a bankruptcy trustee. Every case has a trustee appointed to it, no matter whether it's a Chapter 7 or a Chapter 13.
Is there a general rule, or with your experience, a certain time frame that this takes?
As far as getting the preparation to file or after filing?
After filing.
After
Yeah.
filing in a Chapter 7, you're looking at being in the case for about 3 to 4 months.
Okay.
The creditors' meeting usually takes place about a month after you file, and then assuming everything is in order, you get your discharge 60 days after that.
Okay. Well, that's helpful. And we didn't broach the question on gathering the information because obviously that depends on the client and the situation, and you get various answers, I'm sure.
Absolutely. We have clients who are extremely organized,
Hmm.
and they can get us their documentation within, a week or so. I have other clients who are not so so organized, and it takes them obviously much longer.
I hear you. You had mentioned that there's some possible misconceptions, and some of them might be advice that they get from people who mean well but just aren't, frankly, up to speed. So, what would some of those examples be?
Well, the law changed in 2005, and there
Mhm.
was a misconception for many years, and to a certain degree, still some misconception that you can't file a Chapter 7 or that nobody can qualify for a
Mhm.
Chapter 7. And that is simply not the case. Again, most people that come in to see me, if they're considering a Chapter 7, they're probably going to qualify for a Chapter 7 because of their life
Mhm.
circumstances. Um, Taxes, again, is a big thing that people will walk into my office and say, well, I owe this money to the IRS. I know I can't get rid of it. And that's not necessarily the case either. There are certain circumstances where taxes can be discharged. So you would want to be sure to bring that up to any attorney that you're consulting on a bankruptcy filing. There's also something that I see in my practice, because I do practice family law as well, is when you are going through a divorce or contemplating going through a divorce, if there's a lot of debt, a lot of people think, well, let me just wait until the divorce is over and then I'll take care of it. And that is really a huge error that people make, because in the vast majority of the situations, you're going to want to file a bankruptcy before you get a divorce decree entered. Because of the change in the law, once a divorce decree is entered, you may not be able to discharge certain debts. So it's extremely important, and I encourage, any family law attorney that I know to tell their clients when they see that there's a lot of debt to have their client consult with a bankruptcy attorney.
I'm glad you brought that up, Liza. Divorce is, as we know, is not the time to keep secrets and to put off things to be handled for later. And I've listened to you speak to audiences, and when you talk about bankruptcy during divorce, it just gets more involved. It can be dealt with, but it really has to be mentioned, and there's solutions there. And as you said, afterward, sometimes they're just not there anymore. So.
Correct. And another misconception is that if you're married, you have to file jointly with your spouse. And again, that's not necessarily the case. I file a lot of individual bankruptcies for married people. So I again, would just encourage anyone who is facing financial difficulties to consult with a bankruptcy attorney just to find out what their options are. They may not end up needing to file a bankruptcy. There may be other solutions to their situation, but at least know what their options are and know what they're facing before they go down a road and do something that could negatively impact their ability to file at a later time.
You had mentioned earlier additional concerns or misconceptions that people have, and one of them may be what they think the end result of bankruptcy is, or a stigmatism, if you will. Could you go over that and address what really happens at the end of it and what really doesn't happen at the end of
Okay.
bankruptcy?
Sure. Well, number one, bankruptcy, does go on your credit. A Chapter 7 goes on your credit report for 10 years. A Chapter 13 goes on your credit report for 7 years. There's a misconception that if you file a bankruptcy, you won't be able to get credit for 10 years, Chapter 7. That is not the case at all. Most people who file Chapter 7s will have the ability to reestablish their credit within about 2 years. They'll be able to buy a car. They'll be able to buy a house. So it's not going to prevent them from getting credit for that length of period of time. There's also a concern that it's going to negatively impact their credit more than just the late pays and so forth. And again, most of the clients I see, they're already behind on their payments. They have judgments against them, and those things actually are harder on your credit than a bankruptcy filing. And I've seen cases where I've filed a bankruptcy and their credit score is actually improved as a result.
So putting it off and not addressing it sometimes is a bigger concern than just coming up with a different solution.
That's correct.
Okay.
Yes. And also, people tend to think they're going to try to protect themselves by taking certain actions like, disposing of property, transferring things to friends or relatives, and that can be detrimental in their ability to be able to file a bankruptcy. So before you do anything, find out what your options are and how a bankruptcy might be able to help you.
Well, it's interesting you mentioned that. That's one of the things that I hear from time to time. Someone comes in and they already have a plan, if you will, and they've structured this plan of this asset goes here, I'm reducing this asset, and maybe they're trying, but they're just going in the wrong direction and they're hurting themselves more than they currently know.
Exactly, because like I said, in the paperwork that's filed with the court, we have to look not just at what your current financial situation is, but also going back up to 4 years in some circumstances as to what you've done with your assets. So if you started transferring assets to friends, relatives, whatever, that information's more than likely going to be disclosed to the bankruptcy court, and the Chapter 7 trustee can go back and recover those assets on behalf of the bankruptcy estate. And you certainly don't want to put a friend or relative through that situation. And it's not going to help you getting a discharge either.
No, I agree. The and this just popped into my head, and maybe it's just varies too much by employer. Do you see or have you experienced people when they change employers that a bankruptcy in the past makes a difference if that employer looks at their credit history?
I know that there are some concerns about that. The bankruptcy code actually states that an employer cannot hold a bankruptcy filing against you. I'm not going to say that doesn't happen, but and there are certain positions that a bankruptcy may negatively impact that employment,
Okay.
future employment.
Well, it varies by employer, I understand, but it was important that you mentioned that there's a law or a code, if you will, to protect people. So I think that's important to mention.
Correct.
We talked a little bit about credit card. What we tend to run into also, regardless of age, is maybe someone is in a tight spot with some pending medical bills or hospital bills or whatever. Is that different than discharging credit card debt, or how does that work?
No, medical bills are considered unsecured creditors, just like credit card debt. So again, I do have a lot of clients, tend to be older individuals typically that have medical debt that they need to discharge, and it's going to be dealt with exactly the same way as credit card debt.
Okay. So just gather up the relevant facts and sit down with you and explain the situation.
Correct.
Okay. And it's the same format that you meet with the creditors in that informal setting. And
Yes.
Okay.
Yes. Correct.
okay. Well, I've just learned a lot already.
Awesome.
Okay. Well, where would you like to migrate to now?
So I think maybe we could talk about Chapter 13 a little
Okay.
bit. Again, Chapter 13 is a reorganization, and usually those are for individuals who've fallen behind on their secured debt. So your secured debt is your house, your car. Some people have furniture loans. Also, if you owe a lot of money to the IRS, you might want to be considering a Chapter 13 because the advantage of doing a bankruptcy to deal with your taxes is beneficial because it stops the penalties and interest from accruing on that debt. Whereas if you're in an installment agreement, those penalties and interest continue to accrue. So, people that, if they've had a temporary job loss or temporary illness, and there's a variety of reasons why you might have become delinquent on your house or your car, those are the people that we would definitely look to putting into a Chapter 13. And essentially what it does is it allows you time. Chapter 13 lasts from 3 to 5 years, and allows you time to get caught up on those delinquent payments. The courts do require that those individuals be on wage withholding orders, so the client would need to be aware that their employer, or at least their payroll department, is going to be aware that they're in the bankruptcy. That does cause some concern to individuals, although I've never seen it cause a problem as far as from the employer's perspective. And so, again, if you have fallen behind on your house or your car, I would encourage people, again, go speak to someone before you get to the point where you're facing a foreclosure, because that just makes it more stressful, more time sensitive. We end up having to file what's called an emergency petition to stop a foreclosure, and that just ends up costing more money to do that. So better to be proactive and try to take care of the situation as soon as you know that you're going to have difficulty making those payments.
Makes sense. Just realize you need some help.
Exactly.
Okay.
Right.
Do you find that some of your clients need different categories of bankruptcy, that you need a Chapter 7 along with the Chapter 13, or what happens when it covers those different asset or debt obligations?
Okay. Well, you can only file one chapter of bankruptcy at a time,
Okay.
first of all. There are situations I mentioned earlier about debt limitations, and there are debt limitations in a Chapter 13. So if you have, let's say you've fallen behind on your mortgage, but you have a lot of credit card debt as well, um, a Chapter 7 may help you get rid of all that credit card debt, but it's not going to help you with respect to your house because, you know, you're going to have to be current at the end of that 3 to 4 month period that you're in the Chapter 7, or you're just going to be facing foreclosure. So if you're under the debt limits of a Chapter 13, then I would put you in a Chapter 13 anyway. It doesn't mean you're going to pay 100% of your credit card debt back. And that's another misconception, is that you have to pay, if you're in a 13, you have to pay all of your debt. That's not necessarily true. I have filed Chapter 13 plans where we've paid as little as 0.5% back to their unsecured creditors. It all depends on your budget, you know, and there's also a means test in a Chapter 13 that determines the minimum amount that you have to pay back to your unsecured creditors. So there are circumstances where someone's over the debt limits in a Chapter 13. So we might put them in a Chapter 7, get that debt discharged, and then turn around and file a Chapter 13 for them to reorganize the secured debt.
Okay. These different bankruptcy proceedings, are they private in nature other than the client, the potential creditors, and the attorney? Is it public information that people can look up?
It is public information.
Okay.
I will say, though, that, you know, someone's going to have to look pretty hard to try to find that information.
Sure.
So, you know, most people aren't out there searching to see whether someone has filed for bankruptcy. But yes, it is public information.
Okay. It's not just posted as public information anywhere.
Correct.
Okay. All right.
Yes. Yeah.
Well, that was the question I had. I think it's important. So, okay.
Absolutely.
All right. The time frame with the Chapter 13, is it similar to filing after you have the information with the Chapter 7?
So on a Chapter 13, typically the meeting of creditors is going to be a little bit longer before it's set. Typically it's more like 6 to 8 weeks after you file, you'll have your meeting of creditors. There's also a second hearing in a Chapter 13, which is called the confirmation hearing.
Mm-hmm.
And that is actually in front of a judge. The goal is, when you go to the creditors meeting, to get the trustee to approve your plan. So the attorney's job, once the client comes in, they've retained you for the 13, you've gathered all the information, you're going to prepare the petition, similar to what you do in a Chapter 7, but you're also going to prepare the Chapter 13 plan. That plan tells the creditors how you intend to pay them back. And you have to have that on file within 14 days after you file your petition. The trustee at the meeting of creditors is going to review that plan. The goal, again, is for the trustee to say, I think this plan works. And one of the reasons why the meeting of creditors is longer set after filing is because your first payment under 13 has to be made within 30 days from the date of filing. So usually they want to see that you've made that first plan payment when you show up at the meeting of creditors. So assuming you've made your first plan payment, all your paperwork's in order, your plan works, the trustee should announce at the creditors meeting, I'm approving, you know, I'm recommending confirmation. That's what you want to hear. And then the confirmation hearing is typically just a formality in front of a judge saying, I agree with the trustee, we're going to approve this plan. Sometimes, you know, the trustee has an issue with the plan, and there could be a variety of reasons for that. So you might have to do some amendments. A lot of people get scared when they don't hear that it's being approved at the creditors meeting. You know, those are things that you can easily amend typically and take care of long before the confirmation hearing. What you really don't want is to have to show up at a confirmation hearing with the trustee objecting to your plan or a creditor objecting to your plan.
Well, while I'm listening, that when you have guidance and counseling, this is easy to proceed through, but in no way should someone try to do this on their own. It just is too involved. It's not what we normally do on a day-to-day basis, and there's just so many things that we don't know, and not doing it correctly just seems like a quagmire. So,
Absolutely.
yeah.
And you know, especially at 13 when you're talking about doing a Chapter 13 plan. But in any bankruptcy, Exemptions are so important because, as I stated earlier, you want to protect your assets. You've got to make sure your exemptions are done properly. I've seen trustees take items that would otherwise be exempt that the client attempting to do the case on their own didn't know that they could exempt. So you don't want that to happen to you. Make sure you have competent counsel
I understand.
to help you prepare the documents and get them on file.
You don't want to revisit it twice.
No.
All right. So what else do we need to know about Chapter 13?
So, a Chapter 13, like I said, is there's so many varieties of Chapter 13 plans. I have clients who have seasonal jobs where their income, varies throughout the year. We can do variable plans for them. So you don't necessarily have to make the same plan payment every year. I have a client who gets a lump sum from a promissory note that he entered into once a year. So he makes a large payment once a year and then a smaller payment every month. So there's a lot of flexibility in a Chapter 13. So that's important for people to remember, that the plan is structured to their individual circumstances. We don't have to be, we're not in a cookie cutter situation where we have to follow specific guidelines. I mean, they're guidelines, but not, specific terms. And that's actually what I enjoy most about doing Chapter 13s, is I get to be a little creative and try to, work through each client's individual circumstances to come up with a plan that they can live with for the next 3 to 5 years.
I can see where that would be helpful.
Right.
Well, we're going to take a break, and when we come back, we'll continue with everything you wanted to know about bankruptcy, but we're afraid to ask, and we'll join Liza Greene. Thank you. We'll be back in a moment.
Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.
We're back. This is Planning for Win, Financial Guidance in Life. I'm Kevin Pinkley, and we're going to continue with attorney Liza Greene and everything we wanted to know about bankruptcy, but we're afraid to ask.
Thank you, Kevin. One of the things that we touched on when right before the break was that we do individual plans for people in a Chapter 13.
Mm-hmm.
We can structure something that meets that individual's circumstances. One of the questions I get asked quite frequently by Chapter 13 clients is, well, what happens if I lose my job next year, or, I get sick and I can't make a plan payment for any particular reason? And it's important for people to know that just because you're in a 3 to 5 year plan doesn't mean you're stuck in that particular plan for that length of time. The court recognizes that circumstances may change within that next 3 to 5 year period, and you can do what's called a modification. And so a modification would occur, like if you have a job loss, you have an illness, you get a divorce, then we can request a modification of the plan with the court. You simply, again, fill out some paperwork, file a request for a modification, explain to the court what the change in circumstances are and how you need to amend the plan. And again, as long as it's a legitimate reason for the modification, the courts are typically going to accept those and approve those. And it could change your percentage even of what you end up paying back to your unsecured creditors. You may originally have been able to afford, say, a 50% plan, and now because of your job loss or cut in pay or whatever, perhaps you've been through a divorce and you've lost some income. You may be down to a 5% plan. So there is a lot of flexibility there that people have some concerns about.
Well, I think that's very important to know because, as you're aware, a lot of people's hesitancy to inquire about bankruptcy or to complete a bankruptcy is they think it's carved in stone, if you will, and that once you enter and file, that there's not any flexibility there. So they're almost more afraid of the future than they are of the current situation. And it's good to know that there's possibilities to make changes when needed. So
Absolutely.
important.
Right. Some distinctions I think that are important for people to be aware of as far as Chapter 7 and Chapter 13 and what happens after filing. Again, you're only in a Chapter 7 for a few months. So, once you've got your discharge, for the most part, you can go on with your life, do as you will, purchase whatever you want to purchase, sell any assets that you want to sell. The only exception is your home. If you sell your home within 6 months of filing your bankruptcy and you don't reinvest those proceeds into another home, you can lose your homestead exemption. So that's something important for people to know that are considering a Chapter 7. And I always talk to them if they own a house, what are your intentions? Do you plan to stay here for a while? Are you trying to sell? So that they can be aware of that restriction. The other thing that you could potentially lose in a Chapter 7 after filing is an inheritance. Any inheritance that you receive within 6 months of filing is not exempt and can be taken by the bankruptcy court to pay creditors. In a Chapter 13, you're obviously in it a lot longer. So anything you do while you're in that 13 does require some court supervision. For instance, if you want to sell your house, you can, but you have to get approval from the court to do that. If you want to refinance your home, you have to get approval for that. If you want to get another car because your car is broken down, you have to get approval for that. So there's a lot more overseen by the court in a Chapter 13 situation. But typically, as long as you're making your payments per your plan, the court's not going to interfere with your day-to-day life. Another thing that people think, somebody's going to come into my house and see, what do I really have here? And you're signing the paperwork under penalty of perjury, and the court presumes that you are being truthful. And at the creditors meeting, you're under oath, and the trustee is going to specifically ask you, did you list everything that you own and its true value? So unless, someone comes up in and objects and says, hey, I really think he or she has more than what they've listed here, nobody's going to come and investigate that. They're going to take you at your word.
Okay. Easy enough to follow. Makes sense.
Right.
I'm sorry, you were going to say?
No, well, I was just going to say the other thing I think that needs to be covered, especially since we kind of touched a little bit on divorce and how that might interplay with a bankruptcy. Any bankruptcy case is going to have an automatic stay put in place, and what that means is that your creditors can't come and take any action against you. So the credit card companies are not supposed to be calling you. You're not supposed to be getting sued. If there are lawsuits pending, those are supposed to be stopped, and that includes divorce cases. And that's a big concern for a lot of people. They either have already filed for divorce or they're contemplating wanting to file for divorce soon, and they're concerned about how the bankruptcy is going to affect that. And so I spend time talking to my clients about timing, especially, like I said, in most situations you want to file the bankruptcy before a divorce is finalized. So, I look at what the client's objectives are, how quickly do they actually need to get out of this marriage, or if it's something where they can maybe wait. But there is what's called a motion for relief from stay that can be filed in the bankruptcy case. So even though you file the bankruptcy and the divorce is stayed and cannot go forward, there's ways around that. We can file a motion with the bankruptcy court and ask permission to finalize the divorce if it's a situation where we can't wait. That's obviously especially important in a Chapter 13 because you may not want to wait 3 to 5 years to get your divorce.
I bet, yeah.
Or something could happen during that. You may be happily married at the beginning of the Chapter 13, and halfway through, things go sour, and you want to split up. So we can file the motion for relief from stay and get the court's permission to proceed with the divorce.
I believe you mentioned that if a party is going through a divorce, one party can assume the bankruptcy and leave the other party out of it. Is that correct?
There are situations where an individual spouse can file a bankruptcy. There'd be a variety of reasons for that, uh, especially where the parties have kept their finances separate. You know, husband has all of his own credit card debt, wife has all of her own credit card debt. Then, wife is not having any issues paying hers, but husband, for whatever reason, can't pay his. He can file individually um, his own bankruptcy, and it won't affect the wife in any way. There's also situations where, let's say we have a couple where one of the parties is a stay at home, the other one is the breadwinner. All the debt is joint. You may want to have just one person file that bankruptcy so that you're protecting the credit of the other spouse, and that non-filing spouse still gets the benefit of the discharge. There's what's called a community discharge. So the creditor can't come back against that non-filing spouse to collect that debt. So both parties are protected, even though only one party has got the bankruptcy filing on their credit.
I hear you. I wanted to emphasize, and Liza probably didn't know I was going to do this, but very experienced family law attorneys, divorce attorneys, call Liza and other bankruptcy attorneys like her to get their advice and counsel and help on these divorce cases, because the way I would put it, divorce is one topic and bankruptcy during divorce is a second one. And many, many times you need that added level of expertise, even though you have an experienced family law attorney. And Liza is also a family law attorney, but a lot of your clients come from existing attorneys, correct?
Absolutely.
Yes.
Bankruptcy seems to scare a lot of family law attorneys. Family law attorneys typically tend to stick just to the area of family law.
Right.
And they hear the word bankruptcy and they kind of, I need to, farm this out to somebody who knows what they're talking about. And so, yes, I get a lot of referrals from other family attorneys. Again, when their clients are coming in and they're presenting a lot of debt, they want a consultation on what's the best way to proceed. Do we file now? Do we file later? And like I said, the worst thing that can happen, because it just breaks my heart when someone comes in and says, well, I just got divorced last week, and here's my divorce decree, and I want to file bankruptcy. And I'm looking at the decree, and I'm like, I'm sorry, I can't help you get rid of all this credit card debt because you've assumed it in the divorce case. Now, that being said, a Chapter 13 might be able to help that individual. So there's a distinction between what you can discharge from a divorce perspective in a Chapter 7 versus what you can discharge in a Chapter 13. So again, don't necessarily think all is lost, but you may end up having to pay something back to your creditors in a Chapter 13 that if you had filed before the divorce was finalized, you would have been able to complete the discharge.
So the short answer is bring up the bankruptcy questions and issues during the divorce and not afterwards.
Absolutely.
Okay. Yeah.
Most definitely.
You lose a lot of your options then, is
Correct.
what I would say.
Correct. And it's important to know what your options are. You may decide, hey, I'd rather get this divorce finalized. I'll be okay paying a little bit of this back over time after the divorce case is done. But at least know what those options are, know what you're going to be looking at if you decide to wait, and then you can make an informed decision for yourself.
And let's not let the two spouses work out their bankruptcy agreement, right? Because sometimes we see that maybe.
That's true. Yeah. And I have been called in on occasion when parties are mediating in a divorce where there's a lot of debt to come in and talk to, as a consultant to both parties to determine what's the best course of action. Should they file a joint bankruptcy? Should one of them file? Should they wait? And again, I can't stress the importance of knowing what your options are so that you can make an informed decision about how this is going to affect you in the long run.
Gotcha. Do you see more clients with certain types of bankruptcy versus the other, or does it just cover the whole range of the different bankruptcies that are there?
It tends to kind of go in cycles. Right now I'm seeing a lot of Chapter 13 filings, but then there'll be points in the year when Chapter 7s are on the rise. it just, just really, I've tried to kind of predict out how it's going to be, and it's really impossible to do that. Um, I do see a lot of people, especially recently, who have had not necessarily a job loss, but they've, their income cut. And so that is, I think, 7 seem to be on the upswing right now just because of that. People can't afford to make payments.
Makes sense. So a thought just popped into my head. What about student debt?
And that's a big one.
Okay.
Yeah. Unfortunately, student loans are not dischargeable in any type of bankruptcy case. There is a provision in the bankruptcy code where you can ask for a hardship discharge of a student loan. I will tell you, I've been doing this almost 38 years, and I've only had 2 successful hardship discharges of student loans. Both of them were the individuals were extremely ill, and the kind of the standard is you pretty much have to be on your deathbed or close to it in order to discharge a student loan.
Right.
The courts determined that if you have any possibility of making any sort of payment towards it, you're not going to be able to discharge it.
So know what you're signing up for and buyer beware.
Yes.
What it sounds like. Okay.
Yes, fortunately, there are other programs available to try to negotiate lower payments on your student loans, do forbearances, and there's other options available. And we do walk our clients through those options if they have student loan debt that they're struggling with. But if your only debt is student loan, then a bankruptcy is not going to help you in that situation.
Gotcha. Okay. It sounds like we still need to have a conversation. There
Again,
might be other possibilities.
There could be other ways of dealing with that debt, but bankruptcy is not going to be something that is going to be on the table for that particular individual. The other thing I want to just also emphasize, and this breaks my heart as well, is people will come in and they'll say, okay, I've got to file bankruptcy because I've cashed out my entire 401k to pay this debt, and now I have no retirement left, and I still have a lot of debt that I can't afford to pay back. Retirements are exempt. Don't spend your exempt assets paying an unsecured debt, and then end up in bankruptcy anyway. So again, if you're struggling to make payments, even though you don't really want to file bankruptcy, and you may never have to file bankruptcy, talk to bankruptcy counsel, find out what assets you have that are protected, what a creditor can do to try to collect against their debt. Because a lot of times creditors, you may have to be dealing with harassing phone calls and letters and that kind of thing, but they're not actually going to take any real action against you. And so, and there's ways to get around those harassing phone calls and collection letters. So know what your other options are, something maybe other than bankruptcy that can protect you, but also still protect those assets. You don't want to be in a situation where you've completely wiped out your retirement trying to take care of a credit card debt and then end up where you're right back where you would have been to begin with, filing bankruptcy and still having your retirement.
Well, that example you just mentioned is someone trying to remedy the solution themselves.
Correct.
Without talking to someone first or the correct person. And that seems like a natural answer, but it's really not. And they're probably doing other things that they shouldn't be doing along the way also. So just bypass that hurtful time and that hurtful experience.
Right.
Yeah.
Okay. Right. And, I find that at least most of my clients, they don't, nobody wants to be in my office talking about bankruptcy. That's not something that anyone really aspires to have to do. And so they acknowledge that they've incurred the debt. They feel responsible. They want to try to make good on their obligations. And so they do all these things to try to get this debt paid off. And because of their circumstances, it's just not possible for that to occur. And so, again, as we've been saying all along during this program, find out what your options are. just because you go and consult with a bankruptcy attorney doesn't mean that you're going to file bankruptcy or that you have to file bankruptcy. At least, though, you'll know what to do, hopefully to protect yourself, hopefully protect your assets, and get some relief from creditors if that's an issue that you're facing.
Sound advice. Well, we talked a little bit about 7 and chapter 13. Are there any more misconceptions that you see pretty frequently out there, or?
Again, the big misconceptions are, that they're going to lose something that they really want to protect, that they either don't qualify at all, or they're going to end up having to pay back way more than what they can afford, and that their financial history is going to be ruined forever. Their financial well-being is going to be ruined forever because of a bankruptcy filing. And none of those are the case. There are some obviously repercussions to filing bankruptcy, but most of those are things that you can survive, you can get, recover from, and have a strong financial future for yourself.
Okay. Well, we've covered a lot of ground, and our time's almost up. And I want to thank you, Liza. I think it's been very informative and useful, and we could certainly have another hour or 2 or 3 to talk about bankruptcy, I'm sure. But could you tell the listeners again how they could get in touch with you?
Absolutely. My name's Liza Greene. I work for Laura Dale and Associates. We are in the Galleria area, 1800 St. James Place. And the phone number is 713-600-1717. We'd be happy to speak with anyone that wants to find out what their options are.
Thank you, Liza. And thank you for listening to Planning for Win, Financial Guidance in Life. You can hear us the last Tuesday of the month at 1 p.m., and you can check us out online at Lone Star Community Radio. Thank you very much.
Securities and financial planning offered through LPL Financial, a registered investment advisor. Member FINRA SIPC. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, and financial advisor or tax advisor prior to investing.